all teachers and students, and welcome to the 12th episode of the Constitution and American Life with us, the Friends of Publius. So I have a little rant and a query for my friends. This week begins the 2024-25 session of the Supreme Court, and in this session, the court will address a case of governmental regulation of the ghost gun industry. Now, in their brief, the NRA argued the following. In colonial America, because firearms were essential for food and protection, gun makers appeared wherever the English settled. Many of these gun makers worked in isolated cabins and completed all the work themselves. Their craft was widely celebrated and unregulated. Therefore, so out of the quote from the NRA brief, therefore, government regulation of today's ghost gun industry is unconstitutional, is what they're arguing. This leads me to ask you gentlemen, and predominantly probably Professor Moore, isn't it true in the 18th century that almost all consumer products, including food, wasn't regulated?
Yeah, there was very little. I mean, there was some.
I tried to look. I mean, I looked at carriages. There were carriage taxes, but they didn't regulate the making of the carriage.
Yeah, well, it's the invisible hand, baby.
Right. So, and that's where I'm kind of in a rant. How can that be a legitimate argument going back to 1770 and said, hey, well, there weren't regulations of the gun industry back then. People made them in their cabin, and that's the world we want to go back to today.
Is it going to be linked to an argument about that gun ownership is a fundamental right, and then that's the importance of it? I mean, having a carriage or having food is not a fundamental right, so you can link it to.
Well, I'm sure that's what they're going to try to do, although I think production of the gun and the language of the Second Amendment are coming from two different universes. And this is a California case, all right? And hopefully we know what ghost guns are. And and again, and these things have no serial numbers. They can't be traceable, kind of stuff. But where I'm bothered, Mike, is this so-called legal argument. All right, that this court has carved out, relying on the history of the 18th century to lead us in our understanding of law in the 21st century. Especially this context. Well, let's look at the context of when they wrote the Second Amendment.
Well, I'm kind of looking at this like spaghetti on the wall. I mean, I've not read this, but it would seem to me that the NRA is going to try to throw a lot of spaghetti on the wall and something might stick. And the regulation argument might be one of those that might stick. I mean, we all know that the arguments come into the court and how the court decides may not be the primary argument that they heard during oral argument. So I don't know. Maybe there's a lot of things that the NRA wants in their brief, and this is one of those.
Yeah, could be.
I'm just trying to envision a Ralph Nader writing about carriages unsafe at any speed.
That's good. Thank you, Mr. Kavanaugh. Thank you for getting rid of the blood pressure problem I was just having. I appreciate that there. So let's turn to the Friends of Publius question of the day. 2024.
I thought that was it.
Huh?
I thought that was the question of the day.
No, that was my rant. It was a question I had for my personal issue. This next question is for the teachers and students. The question of the day on this day in this day represents. Wait, excuse me. The question of the day. I'm sorry, I'm confusing things here. 2024 was the 70th anniversary of Brown versus Board of Education, 1954. Recent studies have found that the United States is more segregated today than in 1968. Question is, does this fact lead to the conclusion that Brown was a failed decision? Teachers and students, and explain and discuss why. And by the way, there are a number of scholars who would take the affirmative on that Brown in the end was a failed decision. So it's not that crazy of a question there. So hopefully, and that does relate to the topic we're going to be dealing with here in a minute. But before we get to that, we do have, again, our topic for our friends of Publius, and that is this day in history, minor, moderate, or major moment in history. On this day in 2001, triggered by the September 11th attacks, the Afghanistan war began as U.S. and British warplanes started bombing Taliban targets. Professor Moore, major, moderate, or minor moment in history?
Major.
Woo, okay.
Yeah, because the hip bone is connected to the knee bone. The knee bone is connected to the ankle bone. The ankle bone is connected to toe bone. It's the first in a string of ventures into the Middle East, of which we are still engaged in. So, yeah, it's the first of a new set of dominoes.
Professor Kavanaugh.
Oh, major. It gets us involved in our nation's longest protracted war. I mean, I've had students that, we just got out this last, a year and a half ago. That was the longest war in American history. And you talk about blood and treasure spent. And, to what end? The Taliban's back in control. I mean, to what end did, and then, obviously we leave Afghanistan to go into Iraq and just destabilize the whole Middle East. So it's definitely major.
Professor Williams.
Yes, it's a major event. I would just add that I think the decision to go into Afghanistan, I think made some sense. It did at the time, and I think in terms of what happened on 9/11, it was just the decision what to do after that, as Chris has alluded to, and even have a plan of like, what's the end game there? Is this just like revenge? Are we just angry? We need to strike out and get it done, and then turn back inwards. So it was pretty major because of that, and also because of what it led to.
Well,
Yeah, can I put one more note on there, David? I'm sorry. And to Mike's point, for students, whenever and a lot of our modern warfare is going to be this way, considered to be counterinsurgency, right? Or COIN, as the military calls it. That's the acronym they use. The military as an acronym for everything. And basically, you clear, you hold, and you build. Right? You clear an area of insurgents, you hold the area, but then you have to build in the area because you have to give people something to hold on to in that area that maybe replaces the entity that was there. And you see, and I'm not trying to get all political here, but you kind of see what's going on in Gaza right now, or maybe the West Bank, in terms of the IDF, the Israeli Defense Forces, clearing an area, holding an area, but they're certainly not building anything there for folks. So, and we kind of somewhat failed to do that in Afghanistan, and that I think that hurt us.
well, I was going to argue minor. You've moved me up to moderate, and all I can say is, my gosh, we went there to get rid of the Taliban, and it's 2024. Oh, the Taliban is back, and things are going wonderful for the Afghan people. But you reminded me of, I guess we could conclude the same thing about Vietnam there, and I consider that a major moment in history in 1964. 65. So I'll go with moderate on Afghanistan. So thank you, gentlemen, for your insights there. In today's session, we will be dealing with Unit 3 question on stare decisis and the potential need for reform of the federal judiciary. So let's begin with our 18th century man, and that is Professor Tim Moore from the University of Wisconsin. So Tim, how is the principle of stare decisis related to the function and purpose of the Supreme Court of the United States?
Not directly, because there's no precedence when the Constitution was ratified. Now, having kind of given a snarky answer, I think it's sort of you'll agree with me on that, David?
I started jotting down a lot of things there after you slapped me there on that one. So no, you keep going there, Professor.
No. I think there's two ideas that are related. During the ratification debates, the Anti-Federalists made two arguments that are kind of close to this principle of precedent, stare decisis. One, there's a great essay by Agrippa, and he makes, and other Anti-Federalists make this argument. Look, this federal judiciary will run roughshod over state courts, meaning it's going to run over state level precedents. It's, you know, the jurisdiction will increase and gradually usurp the authority of state courts. So obviously they're concerned about state level precedents being obliterated by this Constitution. Another anti-federalist writer that gets indirectly related to this precedence issue is Brutus 11. We've mentioned Brutus before, and honestly, folks, if you only read one anti-federalist set of writings, Brutus essays, all 15 of them are where you should go. But in Brutus's 11th essay, he talks about this phrase in Article 3 called the equity clause. And he's very concerned about equity because for Brutus, it means that given British tradition of what equity decisions did and equity judges would do, is they would look at all the common law and they didn't have anything that helped them make the current decision in front of them. And so they just made judge-made law. And so Brutus is very concerned about that equity principle potentially being very open-ended. Now that's a half step from overturning precedents. But I think he's pretty prescient there to raise that issue. Another thing he raises is that what if they do make bad decisions? There's no way to check the court in this role, and and maybe overturning a precedent would be defined as overturning a precedent. So the short answer is there's nothing directly there, but I think there is some anti-federalist writings that get to what's going on when many of us perceive precedents being overturned.
Well, I go to the very fact of its existence. The Supreme Court of the United States is not a trial court. All right, it's a court of review, a court of appellate. They're the highest court of appeals to determine what the law is, and it's a court of precedents as it communicates with lower courts. It's a court to help establish a unified system of law, a national law where applicable. And so
there's your federalist argument right there.
So stare decisis goes hand in hand. If it is indeed a court of precedents and they are communicating to lower courts, stare decisis fits that function and purpose in theory.
Correct.
Okay. Chris, you look quizzical there for a minute.
No, just for the students, remember the court actually has two jurisdictions, original and extra crispy. Original and appellate. So, there are cases that will originate in the court as well as, but it really does serve as a court of appeals, as David says. So as the Constitution says, there are cases that will originate in the Supreme Court, but most of the cases end up there just like a banana on appeal.
Okay. Did you have a sip of the wine or something?
No, I always work that into class just to see who's still with me.
Oh, okay. Now I lost my train of thought because I'm thinking about that phrase. That's why I was always in the minor leagues relative to you, Kavanaugh, when it came to teaching. I didn't have those.
A banana chicken recipe. I don't know.
Yeah. Okay, so I'm going to reveal my ignorance, which is not hard to do. So on original cases, the Supreme Court is still on a trial court, though, right? Original cases don't go to the Supreme Court and there's a trial.
No, they're not a fact-finding court.
Right.
I'm going to be careful because I might say some things I could regret. But they're traditionally not a fact-finding court. No, those facts are should be brought into evidence in other lower courts. But I mean, so that's
And that was the anti-federalist criticism of it, that it could ignore facts and just make a decision independent of the facts.
I don't know that our current Supreme Court, Tim, would ever ignore facts and make a decision.
So, Professor Kavanaugh, since you're on a roll, all right, here, the question provides the students with two cases: Brown versus Board of Education, 1954, and Roe versus, or excuse me, Dobbs versus Jackson Women's Health Organization, 2022. It seems to me, by implication, I'm just wondering, is there a similarity in the court's reasoning for rejecting precedent stare decisis in both of those cases, or are there far different reasons for rejecting stare decisis and precedents in those two cases? Are they similar, different? What's your read?
I think the only similarity, David, is the fact that stare decisis was rejected in both. But with Brown, for students, and I'll put some stuff in our show notes for you. Understand this. I mean, there's a whole series of cases leading up to Brown, right? There's a whole series of cases. Sweat v. Painter. I mean, they're looking at grad schools, they're looking at medical schools. Charles Houston, the great lawyer for the NAACP, who brings in a young Thurgood Marshall to help him out. So they're looking in the 1930s. They're already challenging, these cases. And also, this is just me being nerdy. Brown does not reverse Plessy, right? Plessy is, public accommodations transportation. Obviously, Brown is in terms of education, but it does help, to go against Jim Crow.
I guess there's a crack in the foundation of Plessy.
Yes, absolutely. Okay. And so I think there's we're moving forward. Obviously, in Brown, there is the backdrop in the context of the Cold War, and there's a rich history behind Brown. But I mean, there's a whole series of cases and people in the NAACP as well as others challenging existing law, working their way up, and finally getting to the point where you've got Brown et al. By the way, it's et al. ETAL. There are 5 cases rolled together in Brown that the court is going to hear, all dealing usually with separate but equal facilities in public education. So I think that maybe this is just me. I got to be honest here. Maybe it's just me trying to see, okay, maybe we're trying to live up to our ideals expressed in the Declaration of Independence about equality. Maybe we're trying to live up to that promise in the 14th Amendment that everybody's going to be treated equally under the law, all persons. So I think, by the time we get to Brown in 1954, well, argued actually 52 and then argued again, and the members of the court change, and that kind of thing happens, and society changes. So, it's interesting for students to think, okay, so what has changed from 1896 in Plessy to 1954 in Brown? There really are no new laws. I mean, we still have this same 14th Amendment in place. Plessy allows for separate but equal, and actually that becomes the doctrine. And this followed, and it's worked its way throughout society. But society changes over time. Also, as I mentioned, it is the backdrop of the Cold War. And, we're trying to prove that our system is better, and the communists can say, well, look how you treat part of your citizenry simply because of their skin color. So that is an issue there. So I think it's moving that, the arc bending towards justice. Now,
if I can jump in here, Chris, for a moment, the court and legal scholars have kind of come up. The best I could ascertain was kind of 5 reasons that the court could, overturn a precedence. It seems to me that you're saying that that they did so in Brown because, I mean, the 5 that I found were workability, all right, reasoning, the fact there's been changes in facts or changes in conditions, inconsistency with they've made related decisions, which makes this case no longer or inconsistent, or reliance. That is, if you overturn it, we have such a reliance on this kind of stuff. So it seems to me you're saying that they justified doing Brown, and I think it's in the first paragraph, because the system of education, the role of education had changed drastically from 1896 to 1954, which changed some facts. All right, there, kind of stuff.
I'm not sure about that, David. Your assessment of that early on in the decision is accurate, and they're trying to justify, again, they're trying to justify, not following stare decisis, and this is a thing that Justice Jackson, who's on the court, struggled with, right? And they, the whole history behind achieving this unanimous decision, and the Warren Court making sure that it was unanimous. So it was quite the ordeal there, right, in terms of bringing about that unanimity. But those 5 reasons, I don't know that they actually come into play in Brown. And I would, there's a great example here is West Virginia v. Barnett, that ended the idea of standing for the Pledge of Allegiance. In 1940, the court said, yes, in the Go-Bitis decision, you will stand for the Pledge of Allegiance because we need to do that. Just under 3 years later, the court reverses itself in West Virginia Barnett.
Right, but that fits within the list that the scholars and justices have come up with. One, they recognize the workability of their decision. It created more problems. All right, and that the reasoning of the original decision, it was poorly reasoned.
Well, I think the problem.
Well, there are new facts too, because there's all kinds of Jehovah's Witness kids getting beat up.
That's what I'm saying.
That's the point. It's not a workability issue. It's just what happens now. The Supreme Court has given a stamp of approval to persecute people based on their religious beliefs, right? Which is clearly, the whole idea of the First Amendment is just, as Justice Jackson said in his, oh my gosh, his decision in West Virginia v. Barnett is like prose almost. The whole purpose of a Bill of Rights is to separate the vicissitudes of ugliness in society and protect people from things. So I think that, they come up with these ideas about these 5 reasons, when it's okay. And I think that if you go fast forward then to Chief Justice Roberts and his decision in, what's the Citizens United case, right? And he lays it out in Citizens United, about the workability and these things. And this is how we end up with the Dobbs decision. And I think the Dobbs decisions is, in terms of not following stare decisis, is far removed from not following stare decisis in Brown, simply because of and actually more so not just Roe, but also Casey, right? The whole idea of what's laid out in Casey, the case that falls between Roe and Dobbs. So I don't think they're comparable, because I think the court is, you mentioned this, in our lead-in, you're talking about text, history, and tradition. And this is this new way of determining, whether or not something is constitutional. When you mentioned gun control or gun regulation, and I think that you see the same thing that Alito lays out in Dobbs with this text, history, and tradition. But his assessment, and in my opinion, and not just me, but other scholars will believe that his assessment in that regard is a very narrow window when he's looking at these things. So I think and honestly, I think in both cases, it's justices trying to get to a decision they believe is going to be a decision they want to reach, and they're going to find a way to interpret the law to reach that decision.
Oh, yeah. All right. So, and I know maybe you don't necessarily buy it, but like I said, the court was up front in Brown saying, here's why we're doing it. And the court was also up front in Dobbs. There's a variety, but the key thing, according to Alito, is that Roe was wrongly decided. It was reasoned wrongly. So whether we agree with it or not, that does fall into the categories.
I don't think the court was up front in Dobbs.
Huh?
I don't think the court was upfront in Dobbs in the fact that if you're going to rely on this text, history, and tradition going back to what the 17th or 16th century that Alito does in his opinion, and then you completely leave out the last 60 years of jurisprudence and the fact that there was a right for women to be protected. So I'm not sure that I would question Alito's upfrontery, if that's a term.
Well, I mean, this is where it gets tricky, it seems to me, because the court's not going to say what is really going on. And I don't think a lot of us want to say what's really going on, because we want the court and we want stare decisis to be this kind of wall, like, against like just the individual justices as they reason. They're not reasoning in a vacuum. They're coming from a lived experience. They're coming from a political and social context. And those values influence their reasoning. And so depending on who's on the court reasoning and looking at it, they can say with a very straight face, yeah, Roe was just poorly decided. Like, that's not the understanding of substantive due process. Just as a court in 54 could look at the 14th Amendment and say, man, the court in 1896, they just missed it, right? But what's going on behind the scenes is that society has changed, values have changed, and you get people on the court who now see it differently, and the decision's going to change. That is actually what is going on. We are human beings living in a human system, right? And I think that we can't pretend that these justices are just robots, or that they're umpires, as Roberts would like to say. They're human beings. And I think that will get us to another discussion of, okay, then maybe the way we appoint folks, or how long folks can stay, or maybe we want to build in some flexibility as the culture changes, that the court can represent those changes. But I'm jumping ahead. I think that's what's going on.
But you would agree that one distinction is the arc of history. In Brown, we were the people and society. We may not have been ready, as the reaction to Brown might provide evidence, but the arc of history was heading that way. All right, that is a more progressive understanding of race relations and civil rights. That was the direction. In Dobbs, the court seems to be going the opposite direction of where the people are and such. They may be going in the direction of a certain ideological group, but that is opposite, as facts on the ground reveal, of where the American people. So that would be a distinctive difference. Wouldn't you agree, Mike?
Yes, I'd agree with you.
Tim?
Well, I think that's Alito's logic in Roe was wrongly decided. I guess I'm ignorant on this, and I have an opinion out of ignorance.
You're an American.
Yeah, I wonder, and maybe I suspect Chris can shed some light on this. You've made the point, a great point, that there's a lot of precedent that builds up to Brown. Was there, I mean, other than Griswold, was there a ton of, I mean, I know there's a couple privacy cases early in the 20th century, and then you get Griswold. How much, so I guess I'm in the position of defending Alito, I guess. How much precedent was there in the buildup to Roe? And if he's going to make the argument there wasn't much, then he can, with a straight face, say, wrongly decided. So how much precedent pre-Brown versus how much precedent pre-Roe? I don't know the answer to that. But
Well,
would that play into his logic, Roe's wrongly decided?
To Alito's logic,
Yeah.
I don't think he addresses that whole idea of the privacy doctrine prior to Roe, right?
Okay.
And I also post Roe, obviously Planned Parenthood versus Casey. I think this is a very
Right.
important case that students need to be taking a look at as well.
Yeah.
But yeah, that's a great question in terms of the lead up of privacy issues. Not so much because I would, and I don't know this off the top of my head, and I probably should, in terms of were abortions legal prior to Roe in how many places?
10
Right?
states.
Just like in Brown, you
Not
had
many, right, right.
you had places around the country in Brown that were already integrated, right?
Yeah.
There were already integrated schools in places, and even in Topeka, Kansas, there was integration in schools to a certain level. And then when you got to I think high school, then it went that segregation kicked in. So that's a great question. I'm not sure. Mike, you want to jump in here?
Yeah, I mean, I'm on a limb here, but it seems to me that maybe you can make an argument that this precedent we're looking for is all the way back in Carolina Products footnote 4. It's where the court says substantive due process is like, we're no longer going to use it as this way to protect contract. Let's think about how we are a country of expanding rights. I mean, what strikes me about the whole Brown versus Dobbs decisions is, do we factor in whether a decision that overturns something, is it overturning it so that it's expanding rights, or is it restricting rights? Or what I would say is expanding rights, is that just coming from my own ideological, my own social cultural understanding? Because I was very happy that Bowers was overturned, right? Because I saw that as expanding rights. But could someone else see that as, no, what actually happened in that case, Lawrence v. Texas, is it actually restricted rights in some way? Restricted the rights of the individuals in a community to decide the values that they want. It's this
Right.
whole,
Yeah, I know. I don't want to go down that hole there.
Well, I mean, I will for a second, because we see, and actually just coming out of my state of North Dakota, we see, certain federal agent or certain federal programs and sort of maybe protecting people employment, if they're receiving in vitro fertilization treatments, or they're maybe receiving other reproductive treatments, including abortion. And we see that religious organizations are challenging those because they believe they're being forced to support something. And we've seen that in Masterpiece Cake Shop case. We've seen that in a case where the web designer did not want to design a web design for a same-sex couple. So we've seen that argument that my rights as my religious freedom or my freedom of expression is being challenged because of government saying that I would have to bake a cake for a same-sex couple. So we see those arguments now, and it's the judge that just ruled on the case out of North Dakota, saying that religious freedom, religious expression is under attack, and we've seen Alito say that as well, even though he didn't know he was being recorded. That the idea of these religious groups and religious thought is under attack by a more secular society.
Well, Mike, I think we could agree that the march of history, of American constitutional history, was the march of expanding individual rights. And that Dobbs, to my best recollection, Dobbs is the first time that the court is contracting individual rights. I think the flip side of that in Tim's point and Bowers in that whole thing is, okay, is there a collective right of a community to impose their values on individuals? There kind of stuff there. So what I wanted to ask
I'm sorry, but yeah, there is. I mean, that is back to your original question about gun control. This is why we see different areas of the country, and obviously those things are being challenged by folks but you see certain places that restrict access because there's a feeling that, we don't want what types of weapons or some types of regulations. So you see them just jumping in and saying, well, you can't have these weapons.
Well, that's assuming,
laws.
and that's assuming, and that you're reading, and that we read the Second Amendment as providing an individual right to own a weapon, which for our entire history, no court.
That ship's already sailed.
What about?
Well, no, but your point is that doesn't apply, all right, throughout most of our history because no court until 2008 read the Second Amendment as an individual right.
Sure.
Well, now that they do, yes, I would agree with you that now we do have a collective right, theoretically, of the community versus an individual right as the court is designated. there. But before 2008, that was never a question because the Second Amendment was never read to provide for an individual right. Mike?
Yeah, just another quick example is because I think you're right, David. I think that is what makes Dobbs different. But I was thinking back to the West Coast parish case and the overturning of Lochner. And there was a lot of individual employers who would say that decision restricted their individual rights, allowing the government to regulate how would they make contracts with their employees. So I'm just saying maybe there is another example of a court restricting the rights of someone in the business sense in that case.
So it seems like the 20th and 21st century, Mike, have been a plethora of this notion of stare decisis not holding up, and courts frequently overturning previous courts. And as Chris mentioned, the court even overturning itself during the 1940s there. So what I'm wondering, Mike, is does that fact that we have a frequency of overturning precedents in the last 100 years or so reveal a weakness in the design of the system of our Article 3 court?
Maybe. I'm not sure. Let me say why. Because I think, first of all, like empirically, that sense is absolutely right. In terms of the court in the 20th and 21st century has overturned stare decisis much more than in the 19th century, right? But it's like, by my count, by the research I did, 232 times since the founding. So it's about once every year or two, but there have been more in the 20th and 21st century. It's been the same court, it's been the same design since the beginning, right? Maybe the members changing the number of members. Here's what I think we're running into, and Chris has kind of already hit on this. The social context has changed dramatically from the late 19th century with Civil War, new amendments, industrialization, and then comes FDR and the New Deal, then comes the Civil Rights. Like we've been living through this moments of extreme change. And our Constitution, I think where the weakness is that I think Americans today imagine they live in a place where they have way more rights than they actually have as written out. It's a very vague, compromised document. So it doesn't state as clearly, I think, what a lot of Americans would say that we have as rights. And then the court is now forced to make more of these close calls in this vague language. And then there's debates about how do we make that close call? Do we go back to text values from the founding? Do we, as Roosevelt would say, do we go straight to the 14th Amendment? And does that just change everything? And then we see everything through that prism? Some might say, no, we should be reinterpreting what the First Amendment means as society and technology changes. We can't interpret it like we did in 1787 because we have social media and we have, but it makes it an uncomfortable, I think, project to just think we're going to have 9 justices who can just tell us where they think the society is. So I think within that, the weakness, I think, is twofold. It's in that I think our document probably needs to be more precise on what the rights are. And then I think we need to think of a way to get new members on the court in a way where whatever society's pulse is can be better reflected on the court. And so that we don't have members there for so long that they're just not representing where we are as a society. I think that's what I would say where the weaknesses are.
So, Professor Moore, building on something you kind of started talking about, have criticisms of the federal judiciary presented by the anti-federalists, specifically in Brutus 15, played out over the course of American history? That is, in the long run, were they right?
Well, I think, I appreciate the fact you didn't say that Robert Yates was Brutus.
Hey,
I know there's a lot of literature out there on that.
Blame Google AI. It told me.
I know. Well, yeah, whatever. I mean, our I tend to think it was Melanchthon Smith, and it's not a slam dunk, but that's where I would hang my hat. But I would say Brutus, anything he wrote about the courts and any suspicions he has about the courts, I would say he's very prescient. Um, he said, the Federalists said, well, if you got bad judges, they can be impeached. Well, Brutus says, I'll play the BS card on that. The impeachment piece for judges is overrated. It's not going to happen. Okay.
Right.
One for one. He's suspicious about expanding jurisdiction, that federal courts would usurp state courts and everything would become federal issues, federal cases. 2 for 2.
But isn't that due to, wait, can I just check? Isn't that due predominantly to Congress and the people amending the Constitution and the 14th Amendment?
Well, regardless, well, he doesn't know there's a 14th Amendment.
True.
So regardless of that, I think he's still 2 for 2, at least on my scorecard.
Well, let me ask it this way. What was there that trend before the 14th Amendment? Was the court expanding jurisdiction before the 14th Amendment?
I
Chris is
don't,
saying yes.
I'm not going to answer that because I don't know. That ought to go to Chris.
Yes, Gibbons v. Ogden, the national bank cases. So we see that early on, especially with the Commerce Clause.
Yeah, so. Marshall has about 5 or 6 of those commercial decisions that does that.
Okay.
Brutus is also, we're used to saying, that there's the federal Supreme Court is supreme. Now, Brutus, he says right away, this court will be out of control. There's no way to check. There's no way to check bad decisions. And Melanchthon Smith is couching that argument in how the New York system worked. There was a council that could overturn bad judicial decisions. 3 for 3. His 4 for 4 is he's suspicious about the equity clause, that would expand the kinds of cases and untether judges to precedent. So I think he's 4 for 4 on seeing what's coming down the pike. But
so, Professor, go ahead.
No, but talk about, Chris is caveating himself often about Chris's own personal views. I'm an anti-federalist, so of course I'm going to say Brutus was brilliant.
Well,
could you define equity for the students? In, what 1787?
Yeah, that's a fair question. I was kind of being stupid and nerdy there. British equity courts is functioned in this way. As you know, there's this thing called common law, and it's massive. It's just massive. When you think about British history and British precedents, that's called all the common law. Well, British judges occasionally would have a court case, and they're scouring through the library of stuff, and there's nothing in their history, there's nothing in the common law that helps them decide a current case in front of them. So equity judges would do this. What is my best guess? They would make judge-made law that they couldn't find any precedent for. So Brutus, when he sees that phrase equity in Article 3, that was an alarm bell, a fire bell in the night for Brutus. That equity jurisdiction, that's going to mean that judges are going to do judge-made law. So that's kind of the British roots of Brutus's fear about the equity clause.
So, Professor Kavanaugh, Senator Ron Wyden of Oregon just recently introduced a major judicial reform act that would require some significant changes in the organization and power of Article 3 courts. One key change would be to expand the court to 15 justices in a rotating manner, and we can get into that in more detail. But what I'm wondering is, do you think the perceived problems that many people have with the court today justifies these changes?
Well, this is the same kind of discussion we get into with so many things under the Constitution, is it baked into the cake? Is it part of the Constitution itself, or is it operator error? And in this case, I would think, you know, what Aristotle said, you can tell the health of a community by how few laws it has or how many regulations it has. If you don't have a lot, then a healthy community, but the more rules and laws you have a less healthy community because people are not to be trusted. So, I mean, it says a lot about human nature that you have a lot of proposals going on now. And Senator Wyden's he's taking Senator Wyden's proposals. He's taking a lot of different proposals that political scientists have put forward, how we could maybe make the court more reflective of American society. And I think that Mike was alluding to this earlier. You know, I mean, think a few years back, you've got members of the court that are making rulings on decisions about the internet, and at one point, none of them had ever sent an email. So, you know, there's do we want justices to be reflecting society? You know, should we have a recusal process for judges at every level except for the Supreme Court, because the idea is we're going to rely on their, you know, their own ethical behavior. And really, we could see that perhaps right now we have some justices that are not following that. So if you can't, you know, and they came up with this, the court came up with their own like ethical review, but there's no teeth to it. There's no enforcement mechanism to it. So if you guys can't enforce it yourselves, then, you know, the Congress is going to step in, which, by the way, Congress has the authority to do. It's in the Constitution. So when people say that it's unconstitutional, no, it's not. It's in the Constitution that the Congress has the authority to do that. And we see that with the very first Judiciary Act under the new Constitution that establishes the court as 6 members. And then under the Jefferson administration, it drops to 5. And he's like, I'm good with 5. I'll just leave it at 5 for a little bit because I don't want to put anybody else on there. I like the way it's working out. And then it goes up. It goes to a 10 at one point. Then we get it to another Judiciary Act that leaves it at 9. So Congress has the authority. And if the court, and I think public opinion poll would say right now, this is, you know, the court had traditionally been the one branch of government that had really polled pretty well in terms of how people believe the court to be. And now, I mean, their polling numbers in terms of what the people believe about the court, it's getting near congressional level, which is like, you know, that's lower than whale poop at the bottom of the ocean. That's not a very good. That's not very good polling numbers. So, you know, to your question, should we have this? You know, should Senator Wyden or Senator Durbin from Illinois, who's the chairman of the Judiciary Committee, they should be thinking about some types of reform. And not only that, I think the Senate should police themselves as well, because we saw this, you know, when you have justices that may pass away before they're retired. At what point, you know, is the Senate required to actually give prospective members a hearing? So I think this kind of lays out Senator Wyden's proposals, lay that out, but he does want to expand the court to 15, but he wants to do it over a 12-year time period. And I've seen other proposals similar to that would actually allow presidents to appoint people. I mean, case in point, was it President Bush was the last Republican to actually win a popular election. And, you know, you look at the number of justices put on the court by Republicans that now they have a 6-3 majority traditionally in some cases. Is that really reflective of the will of the people? There's a lot to be said about that. So, David, I'm not sure if I'm answering your question.
Well, yeah, I mean, and I go back to something that Mike said earlier, that the court, you know, I think in all honesty should have, you know, some sense of the people. And one, we've had 9 members, a Supreme Court of 9 members, since the 1860s?
Yeah.
Okay. Yet our population is quadrupled. And it would seem logical in my mind that we should have at least the number of Supreme Court justices as we do circuits. And we have 12 circuits and then the Washington, D.C., so we should have at least 13 members of the court. If our Congress can say, you know what, we need to expand circuits because of population, then it would make logical sense that we should expand members of the court. And what I like about Wyden's is recommendation, and it's not his original thought because I've seen it there before, is every president, that after we get it up to 15, every president would then be able to appoint 2 members. We would rotate them out. All right. And that might just diminish the politics. Won't eliminate it, but it might just diminish the politics of the court and appointees and things. If every president is guaranteed 2 appointments. So no, I think you go ahead.
I'm sorry to interrupt, but I mean, just for the students to understand this too, this whole sideshow of confirmation is a very modern concept when it comes to appointments to the court. Going back to Robert Bork, who was appointed by was it Reagan that appointed Bork, but he was not confirmed.
Yeah.
And so his views were considered too far out there, and they took his name and they turned it into a verb and say he got borked, B-O-R-K-E-D. So the concept or the view of this sideshow of the confirmation process is a very modern thing, because if you look at some of the justices that in history may seem somewhat controversial, so many of them are, they sail through the Senate confirmation process. So the idea that the circus that surrounds it now is, and again, there's a lot of outside money flowing into this whole process in terms of, giving perhaps presidents selected names of people that would be good on the court. But that's a modern idea in terms of the circus that surrounds it.
Yeah. Yeah. So Professor Williams, let's take a global perspective here. I'm wondering, in your opinion, do other democratic style nations in the international community provide us some examples, maybe better examples, on how to structure a federal national court system?
Yeah, they sure do, I think. So let me go through some of we've already talked about some of them. The United States is the only democracy in the world where justices serve life appointments, have the opportunity. The only other country that's a democracy that comes close is Brazil. And there they can serve for life, but they have to leave when they're 75. So life ends for them on the court at 75. Every other democratic country in the world has a combination of either term limits or mandatory age retirement. There's no evidence that the function of those courts, the actual rulemaking, has been hampered by this. I didn't look up, but maybe the students could look and see what the current public opinion polls are of Germany's court, France's court, South Africa's court. My gut tells me that they're going to be higher than what the United States is right now. So there's no evidence that it has any ill effects on the functioning of the court or the perception of the court. But some other countries do as well, as they try to build a more consensus kind of model in selecting the justices. And here I'll just talk about South Africa for a minute. South Africa has a Judicial Services Commission, and it's made up of a certain number of lawmakers, like 10 lawmakers. It's made up of a certain number of sitting judges. But then also there are members of civil society, there are faculty, there are professors on it. They get together and there's an opening on the court, they will take applications and they will weed through all the applications, they'll do interviews, and then they give the president 3 names and they say, you choose one of these 3. The president has 2 times where he can kind of go back to the commission and say, I don't like these choices, give me more. But on the 3rd time, those 3, he has to choose from those 3. So the politics of it, the idea is that they're trying to get people who can do the job well. And their idea is that we get a diverse group of people, both from government and from civil society, and we get it. That has proved to be really, really useful for South Africa. And then 2 more, these are kind of stretches. I can't see this fit into our culture, but I just want to share them. One is that in a constitution like South Africa's that has a lot of rights spelled out, there's another section in the Constitution after all the rights are spelled out, and the section is entitled Limitation of Rights. And it's in the Constitution what the court has to consider if they're ever going to limit these rights. So rather than the court come up with its own rubric, which is what we have going on, it's in the Constitution itself, and the court has to follow that sort of rubric when if they ever want to limit a right. And then finally, last but not least, a lot of countries in Europe, and South Africa does this, they have abstract judicial review. So, like, let's say the national legislature is getting ready to pass a bill, and if a certain percentage of the lawmakers say, well, we can't pass this bill, this is unconstitutional, the court will decide before the law is passed and before anyone could be harmed. They will decide on the constitutionality of it, and they may give the legislatures some ideas about what they might want to consider to make the law constitutional. And so it allows the courts, I know this is why, it allows the courts a little bit more of legislating power. It also, I think, tends to diffuse a lot of debates in the legislative branch over laws that the lawmakers clearly know are probably going to be ruled unconstitutional, and they're doing it for just, they're signaling something to their constituents.
Right? Don't we call those advisory opinions? And didn't
Well,
we
right, but we strangled that infant in the crib.
Kind of. We had an informal system. I mean, we know
Yeah.
Frankfurter was up having a drink with FDR quite frequently.
No, I'm talking way back in the 1790s. We could have done this. We could have done this. And the first court decided we're not gonna offer advisory opinions. Which Mike was talking, I'm like, holy cow, we missed an opportunity to be exceptional.
We would just listen to Madison.
Right,
Yep.
right.
All right, very good, Mike. Well, gentlemen, we've come to the end of our discussion on stare decisis and judicial reform. So what recommendations do you have, final thoughts for students and teachers on this Unit 3 topic? Professor Kavanaugh.
Well, I think Senator Wyden's plan is an interesting thing to take a look at, and we'll put a link to it in the show notes. But if you think and I love this about all We the People's questions, really, for students. If you think it's broken or you think it's not working, have some ideas how you would fix it. You don't all have to agree on the panel, because obviously, the people, you're free to disagree, and obviously it shows more varied thinking. But if you think there's a problem, how would you fix it? And so you can use Senator Wyden's plan, or there are other plans out there put out there by other learned people. And if you think it's okay, if you think it's fine, it's served us well for 200 plus years that we've had it, then, stick to your guns on that. So think about if it's not working, how would you fix it? In terms of the two cases in stare decisis, I think you've heard us kind of say this, and Mike alluded to that, the court's makeup of the courts changes, and sometimes people you kind of know how they're going to rule, but sometimes they come up with some idea to try and explain why they rule, like text history and tradition, originalism, or these other theories for constitutional interpretation. Be aware of these different theories for constitutional interpretation. As a matter of fact, when we're recording this, so that I know the National Constitution Center, and I'm going to put a link in the show notes for this, they're having two scholars, and Jonathan, how do you say his name, Tim?
Knapp
is one of the scholars that are going to be debating originalism. So they've not recorded that episode yet, but I'll put a link in the show notes. I would encourage you to take a look at these two scholars going back and forth on terms of originalism and constitutional interpretation. So think about how you on your panel would, if you're a member, if you're up for nomination to be on the Supreme Court, which you could, because according to the Constitution, any of the four of us could be on the court. Any of the students could be on the court. There's no age. There's no citizenship. You have to graduate from law school. So if you know the president personally, he may appoint you. So have an idea on how you would interpret the Constitution.
Mike.
Yeah, I think this is a difficult and a fun question, because I think it forces us to deal with three different principles that are maybe all important, but they're also contradictory. So I would say the premise of why stare decisis is so important is because we need stability in the law, and stare decisis is supposed to give us that stability. So that's one thought. I think we also culturally we want to believe that our Constitution is so good and it's so sacred that we don't want to change it all the time, right? And we've made that, we talked on other episodes how it's just hard to do that. So we have a Constitution that we kind of maybe hold up on a pedestal, maybe more than we should. We want the stare decisis because of stability, but we also want constitutional decisions that are going to affect our daily lives to reflect either the values in society or at least the debates about the values in society. And it's hard to do all those three things with the current structure of the court. So what I think is useful to think through is what of these reforms we've been talking about, or if we were going to do something different with the court, how could you ensure the stability and the sacredness of the Constitution and get a little more of like the court being a vessel to represent maybe where we are as a society a little better? I think there are reforms that could do that, where we wouldn't just turn the court into another political branch, because I don't think any of us want that either.
Professor Moore.
Yeah, I'm going to build on what Mike just said, but by circling back to something David pointed out halfway through our session here. David mentioned that there's five rationales that the court uses if they're going to overturn. Find that document, folks, because I can foresee as you present this in your hearings, you might get some hypotheticals like, well, should X be overturned? Should Y be overturned? Should, fill in the blank with whatever crappy decision that the judge asking the question doesn't like. I think I'm really, really urging you to get a hold of that document that David referenced, the 5 rationales for overturning. Now, whether you agree, and you saw some disagreement between Chris and David on that, but that's irrelevant. But get a hold of that document, because I think that could be very helpful in sorting through some of the difficulties of when to overturn, when not to overturn, how many do you have to hit all 5? I mean, I think that document is really important. It really struck me as we were talking tonight that really is an important piece, I think, in how you should think about this.
And I'd just like to say that to reemphasize Professor Moore's coverage of the Anti-Federalists and their views as expressed in Brutus 15 from the get-go, that there were serious concerns about this institution from the get-go. And one perspective, I think it's the right perspective, is that in the last analysis, the Anti-Federalists were absolutely right about their fears of the court, as we've seen it play out in history. So don't forget about those roots and that debate over Article 3. And again, hopefully we've helped you. I've enjoyed this conversation, gentlemen. The next time that we see and talk to you students, we'll be looking at Unit 5 and my second favorite topic, and that is the religious clauses of the First Amendment, a safe and genteel subject to be talking about amongst the 4 of us. So I look forward to that. Until then, peace, love, yogurt tacos. Bye-bye. Bye-bye.